Well, good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about some bills that have been introduced during this year's legislative session in the Colorado General Assembly, which have some effect on HOAs. Due to the ever-changing nature of these bills that are under construction and some of the late introduction of some of these bills, we are going to discuss the language of the relevant bills as they were introduced, and then we'll discuss any relevant amendments. There are two handouts attached to this webinar. Unfortunately, the PDF copy of this presentation is not cooperating this morning, so I will be following up this presentation with a direct email to all attendees with a PDF copy of the presentation, which is working. I do apologize. There is another PDF document attached to this presentation that has a list of all of the bills that we are going to discuss today and links that'll take you directly to their page on the General Assembly's website. There you'll find more information about the bills, its history, who voted for what, and you may download these handouts by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. In case you're unfamiliar, this is what the GoToWebinar control panel should look like, and the highlighted section shows where you may access at least the one working link for today's handouts. Again, I apologize for the non-working link. We'll get that sent out to everybody as soon as the presentation is over. Please note that the information provided during this presentation is for educational purposes only and is not meant to provide or be construed as legal advice. Any legal questions that you have should be directed to your attorney. Before we get into the presentation topics, I always like to take a moment to talk to you about my office, the HOA Information and Resource Center. The HOA Center is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA Center provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act, also known as Kiowa. It gathers, analyzes, and reports information through complaints and HOA registrations, and writes an annual report to the legislature. Our office creates resource materials, provides education, and presents HOA forums such as this one. And we also maintain a website with information for the public and registers HOAs. As for what my office does not do, the HOA office is not a regulatory program. We do not mediate or arbitrate. We cannot provide legal advice or act as an advocate. We cannot assess fines or penalties, and we do not enforce an HOA's failure to register. As some of you know, the Colorado has adapted the Colorado Common Interest Ownership Act, or CCIOA, we call it Kiowa, effective July 1st of 1992. The statute is intended to create a clear, comprehensive, and uniform framework for the creation and operation of common interest communities, also known as HOAs. The Act governs most common interest communities, which are defined as real estate described in a declaration with respect to which a person, by virtue of such person's ownership of a unit, is obligated to pay for real estate taxes, insurance premiums, maintenance, or improvement of other real estate described in a declaration. Community Association Manager, or CAM, licensing and regulation previously existed in the form of the CAM program housed here at the Division of Real Estate from January 1st, 2015 to July 1st, 2019. In May of 2019, the General Assembly passed House Bill 19-1212, which concerned the recreation of the CAM licensing program. The bill would have continued the CAM licensing program administered by the division for 1 year. However, on May 31st, 2019, Governor Polis vetoed HB 19-1212, and the CAM program expired on June 30th, 2019. In addition to his veto, the governor also issued Executive Order D 2019-006, which directed a stakeholder process to examine community and homeowner associations. Currently, there is no regulatory oversight of HOAs or community association managers. Now that we have a little bit of background on HOA legislation, let's talk about the bills that we have seen been introduced this year, which have some relevance to HOAs. The first bill we'll discuss is a big one. It's HB 21-1229. It was introduced on March 18th of this year and is formally titled Homeowners Associations Governance, Funding, Record Keeping. Its formal description states that it concerns increased protections for unit owners in the governance of unit owners associations under the Colorado Common Interest Ownership Act. We will review the bill as introduced so that you can get an idea of what the intention of this bill was, and then I will review the bill as it currently reads as amended. As introduced, this bill set out to do a lot. It proposed to increase requirements for disclosure and transparency in the operation of HOAs, including a requirement to post on the HOA Information and Resource Center's website the association's governing documents and any amendments to those documents, in addition to recording them in the county and land records as required by current law. It required supplying a list of the HOA's current fees chargeable upon sale of a home in the community to the HOA Information and Resource Center for posting on the center's own website. As introduced, this bill specifically authorized the State Internet Portal Authority, also known as SIPA, to coordinate with the HOA Information and Resource Center to host HOA websites on behalf of registered HOAs, and also required an association to post on a website with the web address communicated annually to all unit owners, the contact information for the HOA and its management company, if any, as well as any other information currently required to be disclosed. All of this was meant to be housed on their website. This bill also set out to penalize HOAs $50 a day for failing to provide access to records which are requested by certified mail and not provided within 30 days past the request. As introduced, this bill allowed unit owners to place items on a meeting agenda by petition, to record any portion of an open meeting, and to invite a registered parliamentarian to observe executive board elections. It also limits the use of proxies by requiring express delegation of a unit owner's voting rights in a signed, dated writing, meaning that proxies would only be transferable upon express consent of the delegated unit owner. So, for example, as introduced in the following scenario, if I give my proxy to Tim, he could not give it to Peter without my express written and signed consent. As introduced, this bill would also prohibit any action to be taken at an open meeting by written or secret ballot unless 20% of the unit owners in attendance or represented by proxy so requested. As introduced, this bill also requires members of an HOA executive board to either certify that they know and fully understand the HOA's governing documents or complete a free online basic training course offered or approved by the HOA Information and Resource Center. Of note is the fact that the HOA Center already has 16 videos focusing on board member education. As introduced, this bill would require an association with 35 units or more that do not employ professional association managers to commission a reserve study at least every 3 years and to adjust the HOA finances accordingly at least annually. Additionally, all contracts for goods or services over a specific dollar amount would be required to be awarded based on a competitive bid process involving at least 3 bids if possible. Under current law, the developer of a subdivision, also known as the declarant, is not required to transfer control of the HOA to executive board members representing the owners of the units in the subdivision until 60 days after the occurrence of one of 3 circumstances. As introduced, this bill would reduce the amount of time that may pass in at least one of the three scenarios before the declarant must turn over control to the HOA to unit owners, regardless of the percentage of units that remain unsold. As introduced, this bill would require any vacancy on the executive board that occurs more than 60 days before the next board election to be filled by a special election rather than by the remaining board members, which is currently allowed. It would prohibit the HOA from closing off or limiting use of the common elements, except for a finite period of time, with advance notice to unit owners and a statement of the reason for the closure. And it also prohibits the selective scheduling of maintenance of common elements to immediately benefit certain units in preference over others. Upon the sale of a unit, current law requires disclosure to the buyer of certain HOA documents. As introduced, this bill would require an association to ensure that the documents provided to a buyer or posted online by the HOA are correct and complete, and it gives the buyer the right to sue for damages if they're not. Associations would also have to disclose whether a loss has occurred to common property that may result in a future assessment against unit owners. The HOA Center frequently hears complaints from recent purchasers of property in an HOA when it is discovered that a special assessment has been issued to cover a deductible for a claim that arose during the previous owner's ownership. Under these circumstances, although the new owner is responsible for the assessment as it was issued during their ownership of the property, since the claim was submitted during the previous owner's ownership, the new owner's home insurance loss assessment coverage usually will not apply. As introduced, this bill would require property and casualty insurers to pay claims for loss assessments based on when the assessment is made rather than when the loss occurred, thus avoiding a potential gap in coverage for the buyer of the unit. HB 21-1229 also adds specificity to the requirement that HOAs allow installation of renewable energy devices, which would still be subject to reasonable aesthetic guidelines by requiring approval or denial of a completed application within 60 days and requiring approval if imposition of the aesthetic guidelines would result in more than a 10% reduction in efficiency or a 10% increase in price. This bill also amends current provisions regarding political yard signs to specify that the election season during which such signs must be permitted begins 45 days before the first mail-in ballots are sent to voters, rather than 45 days before the official date of the election, which is current law, and specifically includes non-vegetative turf grass, also known as artificial turf, among the types of drought-tolerant landscaping materials that the HOA may regulate but not prohibit. And lastly, as introduced, this bill required any dispute between the HOA and a unit owner to be submitted to mediation, either through the Office of Dispute Resolution within the Colorado Judicial Branch or through other available mediation services prior to the commencement of any legal proceeding. The HOA's acceptance of a settlement imposed by the mediator would not preclude the HOA from enforcing covenants or rules in any future proceeding. Since its introduction, HB 21-1229 has been through several amendments. Currently, it has passed the House and then the Senate, although with additional amendments in the Senate, and then sent back to the House to allow for a review and a vote on the Senate amendments, which appears to have happened yesterday evening. And as it currently sits, it appears as though it is waiting for the final vote in the House before it is sent to the governor to be signed. Again, several amendments have occurred. As it currently reads, this bill has been pared down quite a bit from what it was at introduction. So we just talked about a lot of issues here, and only the ones that we'll talk about in a moment are currently still in this bill, but it still contains some additional protections for owners. As currently amended, this bill would still add non-vegetative turf grass to the list of methods of xeriscaping, which an association may regulate but not prohibit. And it specifies that more than a 10% reduction in efficiency or a 10% increase in cost as an unacceptable result of any aesthetic guideline. It would also require HOAs to approve or deny applications for installation of energy efficient device within 60 days, or that application is deemed approved. As amended, this bill would also require that a list of current amounts of all unique and extraordinary fees, assessments, and expenses that are chargeable by the association in connection with the purchase or sale of a unit and are not paid through assessments, including transfer fees, record change fees, and the charge for a status letter or statement of assessments due, be included in the must provide category of records that must be maintained for the purpose of record retention and production to owners. Finally, as amended, this bill would also penalize HOAs $50 per day for failing to provide access to records which are requested by certified mail and are not provided within 30 calendar days beyond the request. Keep an eye on this bill and see if it is signed into law by the governor. Again, you will find a link to this bill, the page on the General Assembly's website, through the handout attached to today's presentation. Again, we are experiencing some technical difficulties, so both handouts did not make it on our presentation today, but I will follow up this presentation with an email to all registered attendees with copies of both of those handouts. And if you're watching this on YouTube, because it will be uploaded to YouTube later today, you may find links to those documents in the comment section below. So HB 21-1229, which we just finished discussing, is by far the largest and most involved of the bills that we'll be talking about today. What's left is mostly single issue bills. And next up is HB 21-1167, which regards private construction contract payments. So this bill specifically limits the amount of money that a property owner may withhold from a contractor or a subcontractor during the term of a construction contract. This amount is usually referred to as retainage. The idea behind retainage is that by withholding a certain amount from the contract price, a contractor or subcontractor is incentivized to complete the work and to do so in a satisfactory manner. The restrictions in this bill limit retention to only 5% of the price of the completed work. HB 21-1167 has been passed by the legislature and has already been signed into law by the governor. Talk a little bit more about this bill. The restrictions in this new law do not apply across the board. The restrictions would only apply to a contract that has a price of at least $150,000 and any subcontract or supply agreement to such a contract. The bill does not apply to a single contract that governs the building of a single-family dwelling, a multifamily dwelling with 4 or fewer family dwelling units, or a contract with a public entity. This bill has passed and has been signed into law. So this new law should be kept in mind by any association that plans on engaging a contractor in the future with regard to any major construction projects, in example, those costing more than $150,000, as there are some greater risks now involved. Since the amount an association may withhold may not cover the costs to complete the project under certain circumstances, boards should be more diligent in conducting their due diligence when vetting potential contractors. Boards should also be ready to be more involved or delegate their authority to their manager and encourage greater involvement in the project management of any large-scale construction projects in order to ensure that the work is completed in a satisfactory manner. Next bill that we'll discuss is HB 21-1283. This is a Vehicle Towing Consumer Protection Bill. This bill requires the Department of Regulatory Agencies to conduct a sunset review of the Public Utilities Commission's regulation of towing carriers in 2023 and moves up the department's sunset review of the towing task force from 2024 to 2023. As part of its sunset review of the Commission's regulation of towing carriers, the department is required to review complaints against towing carriers, consider whether the towing industry and consumers would benefit from a dispute resolution of complaints, consider the reasonableness of rates for recovery, towing, and storage fees, and consider the reasonableness of towing contracts that towing companies enter into with property owners. This bill would also change the composition of the task force. As seen in this slide, the current task force is composed of representatives from a variety of areas relevant to towing, including law enforcement, the towing industry, automobile owners, as well as the insurance industry. This would be changed to replace a member who represents towing carriers but is not a representative of a towing association with a member who represents mobile homeowners, and also replaces a member who represents an association of motor carriers with a member who represents common interest community unit owners. Again, common interest communities are HOAs. The bill also adds 2 members to the task force to represent communities that might be disproportionately affected by non-consensual towing, such as communities of color, immigrant communities, elderly communities, and rural communities. This would affect homeowner associations by giving them a voice on the commission, which could directly affect homeowners and boards through the review of complaints submitted by association members. Additionally, depending on the findings of the task force, some HOAs may choose to change the way they enforce their parking restrictions in order to avoid any claims of discrimination or selective enforcement. This bill has been passed by the legislature and been signed into law by the governor. The next bill we will discuss is HB 21-1310, regarding HOA regulation of flags and signs. If you've been following this year's legislative session, you've undoubtedly heard of this bill. Its stated purpose is to provide additional protections for homeowners' freedoms of expression in an HOA under Kiowa. Current law allows HOAs to ban flags and only limits the application of architectural and landscaping regulations, so as to require that they allow displays of the American flag, service flags such as the Blue Star and Gold Star flags, and political signs subject to specific statutory criteria, but they may ban most other signs or flags. This bill simplifies and broadens these protections, requiring an HOA to permit the display of any flag or any sign at any time, subject only to, quote, reasonable content-neutral limitations such as the number, size, or placement of the flags or signs, or prohibitions against commercial messages. The effect that this would have on HOAs is fairly obvious. Policies regarding flags and signage would have to be amended to comply with the new law. Curiously, this bill has been passed by both chambers of the General Assembly since June 1st, and it still awaits the governor's signature. So keep an eye on that bill as the days move forward. The next bill is HB 21-1108, and it's a bill that updates prohibitions against gender-based discrimination to clarify that individuals who are included in this protected class, The main relevancy to HOAs here is an amendment to the definition of unfair housing practices, which now includes gender identity or gender expression as protected classes with regard to prohibited housing practices. While the effect is less than direct, associations with any sort of anti-discrimination policy may want to review the language in their policy to ensure that they're in line with the new language in the law. This bill has been passed by the legislature and the governor has signed it into law. So the next and final bill that we'll discuss is HB 21-1074, which is titled Immunity for Entities During COVID-19. As introduced, this bill would provide immunity for certain entities from COVID-19 claims so long as they made a good faith effort to follow public health guidelines. While this bill appeared to address an issue that has concerned many associations, it was not able to make it through the entire legislative process and was postponed indefinitely in committee, which means that it stops there and will not move forward.